let's see here. I think phone screen. Let's go here. Continue. Start broadcast. Okay, y'all can see my screen, right? Yeah, can y'all see my screen?
Yes.
Okay. So now y'all don't have Westlaw, so y'all don't necessarily know certain things. So if you see this up on the second row at the top, that little 21, that is 21 places in the Uniform Statutory Trust Entity Act where the term registered agent comes up. Okay. So let's see. Termination of registered agent. This is what, no, not termination. Let's see. Right here, resignation of registered agent. This is what Brian Parker did when he did his common law resignation. And he posted his document in his group on what he did. And it's based on the fact that the principal has not disclosed to you that you are operating in this fact.
You're breaking up.
I just love how the data connection out here in Kansas really stinks. It keeps kicking me off. So what I was saying is Brian Parker, when he resigned as registered agent, he didn't see immediate results, but he did see results down the road with his driving record. And if you know how this all applies to you and you can articulate it according to the law, you can avoid almost all liability that the system tries to put on you. And a trustee decentor is how they're getting you to be liable by saying, for a lack of better terms, that you're operating as the trustee without legal authority to do so.
Right. Oh, good. We're recording this one.
Yeah, I'm recording it. I'm going to put it up on Rumble, depending on how the video goes. I tried to do the screen share. It lasted for a minute, and then I got the notice that it quit sharing. And it's like, really? So the only way I can stay connected is to stay in the app.
All right. So we know who we are, right?
Well,
We know.
Yep.
Okay.
Yes, you have to know who you are. See,
Right.
that's the problem. Is the people don't know, they don't know who they are in as a player in the game. It's a symbiotic relationship. Um, the government is there to protect our rights. The problem is we don't know what they are and how to defend them, and we don't know how this system applies because they don't teach it to us. But honestly, they have no obligation to teach it to you.
Right.
That's your right. Um, if you care to learn, you will learn. If you don't want to learn, guess what? They can't make you.
Agreed. We all have our responsibility to research, find, and figure it out. Really.
Yeah, we do. Um, I tell people all the time, I said, you sit there and blame the judges because I did it. I went through a 7-year court battle and I still don't like the judge, but I respect him now because I look back over that whole time I was studying and learning different things and learning at the time I thought I made the right move. And then he would shoot it down and I would get mad and he's corrupt, he's this. But now I look back over the years and I said, no, he is trapped in a system too. He has certain rules he has to follow. And if he don't follow those rules, he gets in trouble. The problem was I didn't know the rules. And and does that mean I agree with them? No. Do I like the fact that they do it? No. I think judges do have a moral obligation to do what is right in spite of the rules. But they won't last as a judge if they do. So I learned that they are actually, for the most part, very honorable people when they sit on that bench. You just got to learn how to recognize what they do. And that's where our problem is we don't understand the principles of law. And almost all the statutes, codes, rules, and regulations are based on principles. If you learn the principles, you can navigate every single statute there is. Now, I get what you're saying there, but there are also good lawyers that try to do the right thing. And depending on how far they go on trying to do the right thing, they won't last as a bar member. I've seen attorneys get disbarred for actually trying to defend the rights of their clients. There are good attorneys out there. I actually talked to some of them.
Just few and far between, huh?
I think, well, there is a system at play, okay? And everybody is trapped in it. The question is which part do you play when you're trapped in it? And the attorneys are stuck in a system too, because I've had conversations with attorneys about the trust and this, that, and the other, and they can't touch it. They absolutely won't touch it. And I told
maybe
the
that's
attorney,
why they haven't replied to a single filing that I've done,
well,
which automatically disqualifies their case.
No, you presume it does. You're only 6 months into studying. You think you're doing things right. I can tell you now you're not, and I haven't even seen your documents. Because if you were doing things right, you would get results.
The first thing, by disowning the name and turning, well, of course, like last night I said I should have done the Social Security card as well, but the first thing I ever did was saying, I am not Richard Bush. Here is this piece of paper. That is the entity that you are looking for. It's not me. That wasn't the right thing to do.
But you didn't identify who you are.
I did. I didn't identify as that name, the all caps, and later on, and it was entered into evidence, the oral record by the opposition's counsel, that my name is Jeff.
Now,
I'm not Richard Bush.
Yes, but you are still not putting any evidence. You have not created a paper trail. Okay. Now, last night we were talking about the Constitution, and I told you that you haven't even studied it.
Wait, Pastor, there's a bad echo. If you guys aren't, somebody's got to mute out so we can hear.
Let's
see his microphone is picking up what the speaker is doing, so I don't know what kind of microphone he's using.
Just muted it.
Turn your volume down. That might help. It depends on, are you just on your phone using speaker?
Yeah, kind of like that. Pretty much all
That's-
that I have to work with, but
Then that's why
I'll just listen. I've said too much already. Espoused my opinions that seem to be wrong, so I'll just listen.
Now, don't take what I say to you as offensive. You told me last night you're only 6 months into studying this. When I was 6 months into studying this, I wrote a court paper that looked more like a business letter, and I filed it into the court case. The judge made a decision on it like it was a court paper, but he also made the statement, I will accept no more pro se filings. Well, I just knew I was right, and it pissed me off. And I said, he can't do this. And then I discovered United States versus Doherty that he does not have to accept a pro se filing. Okay. And I made other later discoveries to realize in his ruling where I was wrong. That's why I'm telling you, you believe you were right based on what you know.
I have a page full of like the complete opposite Supreme Court rulings saying that pro se litigants are not to be held to the same standard. Like
they're not to be held to the same standard. But do you know there is 4 ways to appear in court? You got in proprietary persona, sui juris, pro per, and pro se. Okay.
Like I put all of them down.
That right there. Yeah. That's what are you wanting to do? The judge to pick which one you are?
I'm everything except in person.
No, in proprietary persona is actually in my proper person. Yes. You want to be in the first 2. You don't want to be in the last 2. The way I explain pro se is this. You're an illegal immigrant. You're trying to get a work visa. We call it pro se. So they give you a temporary unseen bar card to practice law.
Wouldn't non-assumption like encompass it all?
No, that's what a pro se is. You were basically appearing as an unlicensed attorney.
I don't go with the word appearance anymore, because appearance meaning that you are faking to be something that you are not. You're appearing to be, but you're not. I
don't disagree with that, but here's where your lack of understanding comes in. You are playing the part of the dummy. Okay?
I'm an unabashed legal idiot. Yes, I am.
No, that is not what Black's Law definition for dummy is. Okay?
I'm in for idiot, but...
No, an idiot is someone that is not part of their society, not professional.
And that's what I claim to be.
Okay, now, let's see here.
I'm a proud idiot.
When I did the GSA bond process, that's when I made the discovery of you're playing the part of the dummy. Okay? And by the way, one of the problems you have is it's against your significant other. Yeah. You're going to have a hard time rebutting what she says you are, because it is presumed she knows you.
She's an incompetent minor because she can't handle her affairs in commerce, according to CFR 31 CFR 363.
Just because you say it doesn't mean it's factual evidence.
I can say that all of her evidence is hearsay, and there's no proof of it, and the circumstances surrounding her accusations are proven. Like, she made the accusations after she had already been gone for a week, because I had told her that I was going to tell her that she slapped our daughter in the face like twice in custody. So she just made up this stuff. But
Okay, she slapped your daughter in the
regardless
face.
of all the other fraud that's happened. And her affidavit, her original affidavit, in every form they've ever submitted, especially her initial testimony, it said under oath, but it did not say under penalty of perjury, which is required according to 28 USC 1746, something like that. Affidavits are required to be admissible, to be done under penalty of perjury, or it's not valid.
See, here's part of the problem. What you're doing in your case is you are mixing jurisdictions. If your case was just a case where the state had come after you, it would be under admiralty jurisdiction. The problem is
because it's totally backwards. It's guilty until proven innocent, which is totally backwards.
No. The problem here is you are against her, and the state has her interest. She's the witness. You're not properly rebutting everything she says. You are throwing things at the wall, hoping it sticks. I already told you the Self versus Ray citation that you said is a false citation. Guess what? The judge knows this stuff. You're not confirming what people are telling you. You're bringing it to court. So guess what you were actually saying to the court? You are an idiot. You are ignorant because you're bringing in misinformation and not even making it qualify as proper evidence. It's hearsay.
I've realized that I've relied too much on case precedent, and ever since the last court date, I have been doing nothing but combing through the rules of evidence, the rules of civil procedure, and marking out and identifying everywhere where there is discrepancies.
But you know what you're not doing? You're not taking those legal documents. It's not the fact of whether or not you use precedent or statutes or codes or rules or regulations. It's not the point of whether or not you use them. What you're bringing in is considered hearsay because you're not bringing it in correctly.
Yours was hearsay too. Nothing but.
No. Let me go find it. You're going to have to give me a minute to find it.
What was it? I still need to find out that one rule or something that says that it is not necessary to exhaust the administrative process to bring a claim of fraud.
Let me find. David Roach brought this to my attention. I just got to find it. I guess I'm going to have to search for it because I'm not finding his folder.
I'm buried in mountains of paperwork myself too, and screenshots. So
no, it's I thought I had a folder with his that had all his emails. We made this discovery in Indiana. See, a lot of people have no true knowledge of the importance of authentication. Okay? Authentication is a legal process. The point of it is when you do the authentication of documents, it is no longer considered hearsay if the Secretary of State authenticates it. It now meets the rules of evidence. You're not authenticating your documents.
I turned them in like face to face with the county clerk.
No. The county clerk doesn't authenticate legal documents. Let's see here. See, he sent me the Indiana rule, and then I went and confirmed it in another state. In Indiana, it has the best explanation.
I've got to find my rebuttal to that, but I know I've seen where, especially like the clerks can't deny any filing whatsoever, which I have been denied in other cases, and but as far as authentication goes, I swear I've seen something that says whenever it is filed, like it's especially another one about authenticating documents. I'm going to do a little searching myself over here. I'll get back with y'all.
Certain documents are self-authenticating. Yes. You're in Texas, right?
Yes, sir.
An Indiana court case is not self-authenticating. A Texas court case is. A Supreme Court case is.
Exactly, and
Okay.
there's court
now.
There.
But you're not always using Supreme Court cases, and you're not even verifying that the citation is accurate. You're just using a citation that somebody put online that sounds good.
I guess I do need to be more thorough about reading up on every single one. That's a ton of them, but there is Supreme Court cases where it says all Supreme Court rulings apply to state level courts, and that the constitutionality or the fact that it was passable in other states means that other states are referenceable and in cases in different states.
Other state cases are referenceable, correct, but you can't do them as authoritative. When you're trying to do legislative intent, yes. When you're trying to argue the intent of the legislature in the state of Texas, yes, you can use other states' cases as a persuasive argument. In other words, see, the legislature understood it to mean this here in Texas because this is the normal process in these other states. Okay? But you can't use it as stare decisis as authority. Now, listen to this. This is Indiana Administrative Code. Because all these courts are administrative. Okay? Let's see here.
I realize that. I'm going to post something about the Secretary of State, I believe, Department of Indiana.
No, now listen, paragraph A. No evidence shall be admitted into a hearing to attack collaterally any violation pertinent to the matters being heard other than by authenticated or certified judicial record showing either of the following. One, that the convicting court or the court rendering judgment did not have jurisdiction so to convict or to render such judgment. Two, that such convicted court or the court rendering judgment has not in fact rendered a determination of conviction or rendering a final judgment in such case, and that such cause is still pending. And B, any matter appearing before the Bureau's record shall be prima facie evidence of the information that appears on the face of the records. But what does it say in the first paragraph? Other than by authenticated or certified judicial record. So what do? If you're going to use these statutes, codes, rules, regulations, and court cases, print them out in their entirety. Take them to the Secretary of State. Have them authenticated.
Did
now
you not just mention
them as evidence?
Did you not just mention one of the stipulations being rendering a judgment regarding a topic or an issue that has not been adjudged yet as being one of
of it?
Because they totally have done that when I still have not even gone to court for said allegations. That's a separate freaking court matter that I haven't even gone to yet. The false accusation of family violence, and they've already judged about that in the custody battle, which I wasn't even convicted of family violence yet.
Yeah, but you know why they're doing it? Are you objecting to anything the attorneys are saying?
I did to some things, maybe not to the extent that I should have because I wasn't prepared, but there is no statute of limitations on fraud.
You got to prove fraud, and it's the hardest thing to prove.
Constructive might be a little bit easier.
What is constructive fraud?
I think the main stipulation is that intent doesn't need to be proven, even though it is blatant as daylight. But
that is not constructive fraud, brother. What is constructive fraud? If you're going to say something applies, you better know what it is and how it applies.
It's really hard to remember everything. I'm trying
constructive fraud has not. You're right. There doesn't have to be any intent to defraud. Constructive fraud is where the court has to review the contract to see if fraud was built into the contract.
Being how I contested joinder of parties because from the beginning and blatantly said I do not consent to these proceedings even before months before the first proceeding. I don't know what else to do.
Because why?
I know some people would say that just because I replied, I consented, but how could I just ignore everything in this type of case?
You can't ignore.
I would just get a defaulted judgment against.
When you went to court the very first day and he called the name, what did you say?
I'm here in regards to that matter.
Okay, now, what did the judge say after that?
Hardly. I don't think you said anything.
Yeah, you said I'm here in regards to that matter. You accepted the matter.
I should have. I wasn't as prepared as I should have been. I do realize that, but I know what I went through.
6
and
months, you still are not prepared.
I won't give up until I am. I won't give up until I achieve the victory that I know. I just, for anything else, just to set the record straight, even. Just clear my name. I will never give up.
I do not blame you one bit. It took me 7 years to beat that court case. Now, do we have any hard factual evidence that me doing the GSA bonds did it? Not necessarily. We did see results that didn't quite line up. As in, my 5th court-appointed attorney said I was interfering with his fiduciary duty, and he admitted to the funds and the accounts behind the scenes. And then on a recorded phone call, he said he couldn't talk to me about that because of attorney-client privilege. Wait a minute. thought that was your attorney. I said, no, he's not my attorney. He represents the estate. I am merely the dummy in this matter. Okay? Now let me read to you the dummy.
So that's the trick. The GSA bonds, the SF24, SF25A. We can actually fill those out on our own, huh?
I actually did them in that case. Okay,
Well,
let's see.
Well, by golly, that's the next thing I'm going to do. I've got them printed out already. I just wasn't exactly sure about.
Here's the first definition of the word dummy. A party who has no interest in a transaction but participates to help achieve a legal goal. Second definition. A party who purchases property and holds legal title of another. And then what does it say after that second definition? CF, or compare. CF means compare. And it says to strawman definition 3. When you read strawman definition 3, it brings you right back to definition 2 of the word dummy. So you're there to participate, to play a part. You are not playing the part well.
Now, the last thing that I did in the last court case, right before he issued these insane orders, I did file a 2848 power of attorney as my God-given name as Jeff, power of attorney for Richard Bush, and I gave the trustee, the presiding trustee, Trader, a Form 56, giving him, binding him to his fiduciary duties, and told him I was claiming my minor accounts and told him to offset all charges, and he just blew it off.
You know why he blew it off? You were 6 months into this. You filed things into the case. You were throwing things at the wall to see what stuck. You didn't even know how to defend the very documents you were doing. And he knew that.
That's why I'm taking my time this time to make this appeal impregnable.
Can I say something real quick, Pastor? And I don't want to butt in or anything, but see you. I'm not sure what your name, or Jeff. You just said your name was Jeff. I just want to say that when I first came into this, I was the exact same way. I was hard-headed. I was right. Everybody else was wrong. I was pointing fingers. I didn't want to listen because I was so stuck on doing a certain thing. But let me just say, with a big, huge open heart, we understand what you're going through and we want to help you. But you have to be able to help yourself, take constructive criticism, and be able to listen to what people are saying with an open mind and an open heart, because that's the only way you're going to get through this. I'm just saying that, like I said, just to try to help you to wrap all this around your head. It may take a bit, but trust me, when you start doing what Pastor and JW and Floyd are talking about, and Boris, I think, even talks about it sometimes, these guys know what they're doing. These guys have been there. So just take a step back, relax and breathe, and just listen to what they're saying, okay? That's it. I yield.
I totally get everything you're saying. I'm all ears. I'm here to learn. I'm not trying to be combative. It's just frustrating. Knowing that I'm right, but I'm not claiming to know everything. I know that I'm not as prepared as I need to be, but I know that I'm right. But I just need to.
I want to say
Yes, sir.
thank you to Beth, but my wife can attest.
I do as well.
And Jeff, I sounded just like you when I first started.
You still sound that way sometimes.
Yeah, so I knew what they did was illegal. I even had the very first court-appointed attorney admit what they did was illegal, but he could do nothing to stop it. Okay, I got it recorded. It's on video that what the state did to me and my wife was illegal. Okay, I knew I was in the right. I sounded just like you. I was throwing everything at it that I could to protect my family. So I feel your pain. I absolutely understand where you're at, because there is a psychological mindset that I see in everybody. When the state has come against you, everybody pretty much does the same thing. They start out with, hear my story. Drove my wife absolutely crazy when I was doing that, because my wife is more private. Okay. I started throwing things at the wall to see what would stick. Did what I was reading, but I didn't have the wisdom to understand how to make it stick. Okay. It took me a long time to get to the point where I started gaining the knowledge, one, where I was getting the respect of attorneys in the things I was saying. Because why? They are experts at this system. When you start getting to the point where you are teaching attorneys things that they knew but didn't necessarily know how it applied, you know you're on the right track. Until then, you're just looked at like, really? And it's not that they mean bad. They're trapped in a system too. They have certain rules they have to follow. I mean, I basically, without saying it, told the judge in our case, fuck you, I ain't coming back. And I didn't. I
You
kept
didn't.
my word. Do what, dear?
I said that you didn't. As a matter of
Mm-hmm.
fact, I think for the rest of our court case, you had warrants for your arrest.
Uh-huh. And those did not get dismissed until I did the GSA bonds. And the judge actually changed how he talked about me, how he treated anything relating to me. He's even said he had it out to get me until I did that.
How do you submit them?
What did I submit?
I don't submit anything, but how do you file it?
Do what, dear? You started to say something, honey.
No, you're good. Answer his question. He wanted to know how you submit them.
You got to fill out you got to fill out all the forms the right way. You got to get the initial presentment. The initial presentment was the petition. That's the negotiable instrument. You also got to attach a true copy of your birth certificate to that presentment. And you create a packet. And you send that entire packet, the original copies, privately registered mail, restricted delivery, to the judge. Then you send a copy to the county executive, to risk management, to the lieutenant general at the Army Corps of Engineers, and to GSA.
Gonna have to get a pen real quick so I can jot that down. Let's see. What else was I going to say? Isn't it against one of their codes to make copies of just like not certified copies, just like paper copies off of our printer of said certificates? I think I've come across something like that. But you said Army Corps of Engineers, huh?
The lieutenant general is the person that runs the Army Corps of Engineers. They got a gold fringe flag, right?
Yeah, true.
Okay.
Saying
Army
something he denied
regulation,
as well.
no, under Army Regulation 84-10, okay?
It's probably the third thing that I said
Yeah,
initially.
under Army Regulation 84-10, it can only fly in military controlled areas. Well, guess what they did? They contracted with the military through the Cage Code.
That's a new one, Cage Code. Yeah, but he just laughed off the code for the 84-10 or 2-6 gold fringe. Hell, he even denied admiralty jurisdiction whenever admiralty is actually in the Constitution. He claimed that it was an Article 3 court of record when it's clearly not. It's Article 1, Section 8 under supervision of Congress. It's not that's just one of the many lies. Like,
Are you talking about David Strait? Yeah.
No, the judge. The judge
Oh, the
denied
judge.
admiralty jurisdiction, and he denied anything about the gold fringe flag. It's like it's freaking nonsense. So just
He denied it
out.
because why? Everything you were saying was hearsay. You have not put one stitch of credible evidence into the court.
That's what it's so hard to accept. Like it's just hearsay evidence, but it's in their code. I mean, come on. Like how
did I not just explain to you the purpose of authentication? The authentication it meets the rules of evidence. Until that statute code or whatever, you have to argue the fact of whether or not it is self-authenticating. You have to know that. If it is not self-authenticating, then you need to authenticate it. Once you authenticate it, then the judge has to take judicial notice of it because now it meets the rules of evidence.
if we have to abide by those rules, shouldn't the presiding administrator have to follow the same exact rules and not just say the codes, but actually produce a certification of constitutionality of the said codes that they themselves rely on? Because they don't. They just recite them just the same.
Do you know why the courts interpret the law?
To their prejudicial preferences, yes.
No,
with judicial discretion.
One, the reason why they interpret the law is one, nobody brings the law to court.
Yeah, not allowed to. No factor truth shall be tried.
Well, what are statutes and codes?
Not law.
That's right. They're only prima facie evidence of a law.
Hey, can I intervene here and say something?
Yeah,
Pastor?
Jesse, I'm gonna look something up right quick. You go ahead and take over.
Everything is based upon hearsay, man. You know, idealistically speaking, they should be doing all the things that you're saying, but that's not how it works. And you're going into someone else's house, right? And when you go into someone else's house, they make the rules. So
under the rules.
Yeah, you need to be taking that into account at all times. Quit thinking that they're going to do something that they're not acting in honor. It's incumbent upon you to act in honor and for you to bring your rights with you, right? So if there's nothing on the record, then what are we talking about here, right? Everything is based upon hearsay. So it's kind of like when you create your own trust and you put your own bylaws in the trust. Well, you don't allow anything outside of that to dictate the terms and the definitions of those words. So you create them yourself to define what it exactly or precisely what it is that you're talking about. And then you take that with you, right? You're not just going in there on their terms and allowing them to dictate what this definition means or what this law is, because if you do, they're going to interpret it. It's open for subject interpretation, and they're going to use their interpretation that's most favorable and enlightened to them, right? So like Pastor's saying, you need to bring your law in there with you, and you need to substantiate it, get it on the record, so that when you go up there, you can say, Your Honor, can you please take judicial notice of said such and such, right? And then you put them on the record, and you don't give them no other choice. You're just going up there and arguing, and nobody gives a damn about what you think something should be. I mean, I know that's kind of harsh, but that's the reality of the situation. They don't care what you think. Anything that comes out your mouth that you can't substantiate is hearsay. And I yield.
Okay, now, I just shared a link in the group. Okay, this is called the bill drafting guides. Oh, if you look at the link, most of your states are published. You are in Texas. You can download it right there. Okay? The reason why they interpret the law is nobody is holding them to what the drafting manual says. The attorneys don't read the drafting manual. The legislature don't read the drafting manual. That's the reason why when a new bill is put into the House, what does it have to do? It has to go to a judicial committee. The judicial committee then goes to the bill drafting guide and makes corrections before they vote on it. You want to get to where you write the law, you need to study your state drafting manual. It will tell you what words mean, how they are to be used, and how to use them correctly. That way they can't interpret nothing after that.
I've been picking apart their paperwork as far as, with David Windmiller's Parse syntax. And
that's a load of crap.
Like,
gosh, get away from that. The legislature has the authority, according to the Constitution, at the state and the federal level, to write the law. They also have the power to define what words mean. The problem is you are listening to other people and assuming they know what the hell they're talking about and using their process, and you're getting it rammed in your ass. I just gave you the source on how to do the law, and you went to David Windmiller. And you're getting beat every which way you turn. Use their stuff against them.
I'm here to learn.
I know you are. David Windmiller and Robert J. Gould are so full of crap. They actually did a good thing when it comes to grammar, but they went overboard when they started getting into all the dash crap. The Bible lays out the principles. When Jesus put the child on his lap and said that you are to come to God as a child would. If you've got a child, if you say to your child and say, I'm going to the store, do you want anything? Well, yeah, can you get me a candy bar, Dad? Well, yeah, sure, I'll be back in a moment. Does that child go start explaining away everything you say? Oh, Dad meant this because of this word means this and this word means that. No. But what do? We make things difficult.
Unfortunately, they weren't quite at that stage yet, but they were at the stage of pitching a fit whenever they wanted something that they couldn't get. But because my oldest is 5, and I've got 3 of them. So, but
I learned this principle because of the void for vagueness doctrine. Every law has to be written in such a way that the common man and woman can understand it. If it is not, it is void for vagueness and unconstitutional and unenforceable. That's why I'm telling you, you got to go to their source information to see what they mean.
What about the 72-hour right of rescission? Because that's exactly what I did to all the documents that they did, especially on this past appearance, or quotation marks. But I wrote void. Your offer to contract is not accepted on every first page of the document.
It wasn't the court's offer to contract. It was your significance other that created the contract. You're going after the court. The court is only trying to settle a controversy. Who is the controversy between?
That's all they're doing. They're the arbiter in between.
Yeah. You and her have the controversy. The court's the innocent party. You are throwing things at the court like they're the bad guys.
Well, I have a question. Did you,
What?
not you, for Jeff here, since you put void and no contract on these presentments, how did you, when you endorsed the instrument, how did you endorse it?
Jeff, power of attorney. This contract is void for fraud upon the court, according to Title 18, Section 1342, color of law. And because it is color of law.
Listen to what I'm saying here. I'm the police officer. I just pulled you over, and I'm writing you up a citation, and I present it to you. How do you endorse the instrument? What did you do with that instrument?
Now I would say your offer to contract is not accepted, written in red ink, diagonally.
Wrong, Jeff, wrong. You got to agree with thy adversary as quickly as possible, because you know what? If you don't sign that ticket, or you don't, you're sitting there and you're going to try to create some controversy on the side of the road, the police officer is liable to pull your ass out and put a knot on your head to take you to jail. What you do is agree with thy adversary, and you endorse that instrument with a byline, and you make a reservation of rights on it. Then you give him his copy, and you take yours back, and then you void it, and you send it to the proper channels within 72 hours. You don't create a controversy on the side of the road. You want to agree with his ass and be on your way as soon as possible. So you're creating a remedy, or you're putting an estoppel in their system before you ever get to the court, so that when you bring up those titles, you can say, hey, this is not a negotiable instrument. It was perpetrated in fraud, or whatever the terms may be. And then you can bring up those things and say, under these titles, these things, or this United States Code, or whatever it is that you're going to use to back up what you're saying. You see what I'm saying? You're not trying to argue with these people. You're just going in there and you're saying that this is not a valid contract, but you have to establish it's not a valid contract before you ever get there.
I get what you're saying. I should have just signed it and used UCC 1-308, reserve all rights, and not create a controversy, which is what I did in the court case initially too. I said, I'm not the name. Here's the certificate. That's the entity that you are inquiring about, and use the securities on that bond to settle all matters. And I was
did you file it on the record? See, I mean, there's two parts to getting something on the record. There's you just going and filing it, and then there's you actually knowing that you're on the record, and then you saying, hey, judicial notice of such and such, and then you take it and you read it yourself, or you make the presentment. Right? It's not just you going and filing it on the record in your case. You've got to get it on the record, right? You only have the rights that you bring with you. So you got to, every step you make, you've got to be creating a record so that you have something to go back to reference that they can't deny. The record is everything, man. What's on the record is the only thing that matters. It does not matter what comes out of your mouth. Okay? It's irrelevant what's coming out of your mouth if it does not match up to the record. They're just going to ignore you or think that you're just babbling.
The record, if you think of the record as in the mouth of 2 or 3 witnesses, First, it comes out your mouth. Second, it's on paper. The paper goes into the file. Does what came out of your mouth in the transcripts match what's in the file?
I thought even if it's not filed before the case, even other opposing lawyers introduce new presentments
Yeah, but
during
you're not a lawyer.
the
You're not a
trial.
lawyer, and they're not going to give you the same respect that they give those guys until
I
you
should be
make them
above them.
respect you.
It should be whatever I say goes. I'm like they're. Well,
It's
No, it
not
is
though, bro.
not
That's not
whatever
how it
you
works.
say goes. That's not how it works.
I know it's not that way. I'm just saying. To me, it should be, and
It's never been that way. Even
they
attorneys, you need to go read the court case, Trenzi versus Pagliaro. Even an attorney cannot. The only reason their stuff is accepted on the record is because nobody objects to the fact that everything they say is hearsay. Because why? Trenzi versus Pagliaro. They have no firsthand knowledge.
I use that.
No, all they at the end of the day really have is your silence, this acquiescence that you're just going along with this process.
I've got the record to prove otherwise. I've got the oral, the oral record, because that's the only one that they used, and it's not even a court of record. It's not an Article 3 court. Who knows what they've hidden?
Oh, they obfuscate everything. That's what they do. They'll even change the record if they have to.
Yeah, because it's a private bar guild matter.
Yep, absolutely. Well, the best thing to do is just to try to stay out of their venues at all costs. You know, if you can figure out how to do the administrative process where you don't have to go in there, I would recommend that. You know, I know.
I'm not sure how much longer I can suffer this injustice, though.
I did
without
it for 7
losing.
years.
All I know is if you go into their venue, you're always likely to get thrown in jail. So you just got to be prepared for that.
I've been there, done that. I got the T-shirt, but it's just I'm studying my ass off to show myself approved, and I'm determined to get there.
Well,
I know you're determined.
And then get all your debts in the public settled, and then just walk away from that shit. Be done with it. Quit trying to fight them, right? Stop fighting them and become the principal so they'll start protecting you instead of you going to war with them, because you're not going to win. You're not going to win a commercial war against them. They've got all the manpower and everybody's on their side.
I try to agree, with them rapidly. Agree with our adversary rapidly and give Caesar what is Caesar's.
But in this case, your adversary is her. She is the reason why this has started. And the state wants to be her husband, so they take the interest in her case to come to her aid.
But I know, and I'm all ears. I'm not trying to argue at all. It's just I was not in the capacity of an incompetent minor because I was not having somebody speak for me.
That doesn't prove you're not a minor. If you would have actually not argued the case, which is what you have done, everything you've told me you've done has argued the public debt. You've argued the case.
Even trying to turn over the bonds. I mean,
where's your evidence there's bonds?
I actually found my CUSIP number from my birth certificate. I wrote it down. I found it.
How did
on
you
Fidelity?
Find it?
On Fidelity.
I bet you didn't.
Hey Jeff.
Some pictures of all the numbers.
Jeff, Do you
Yeah.
understand what Pastor is saying when he's saying that you are arguing the national debt? Do you grasp what he's saying by that?
I
So back in 1933, when they created the New Deal, they put a provision in there that said that the national debt is not to be questioned. Right. So anytime you go in somewhere and you argue, you're creating a controversy, which is basically saying that you're arguing over this debt that's owed. Right. And it puts you in dishonor. So you don't ever want to go in there and argue with them. You don't want to create a controversy. You're in here as a third party intervener on behalf, of the Sister KV Trust, or however you want to, put it out there, and that you're going to surrender over to the court and give them whatever they want, right? Because you're going to agree with our adversary. Never go in there and create a controversy. Never go in there and say you're guilty or innocent, because now you're arguing, you're creating a controversy. I'm innocent until proven guilty only. It's all a trap to get you in controversy so that they can come in and settle the dispute. That's what the Civil War is all about.
and I know exactly what. I don't know how to say that I tried that. I'm like, I turned over the certificate. I'm like, I don't want to create it. I specifically said that while I was doing it. I don't wish to create any controversy. I wish to settle this matter, this debt right now.
You did at arraignment, did you not? Did you create a controversy at arraignment? What did you plead? Did you plead guilty, not guilty? What did you do at arraignment?
This is a custody battle, so it was a plea.
So it's private, then, so that's different. Okay, did you have a marriage license?
No, we were not married. We were together for 6 years, but we were not married. No, I would never marry you.
No. This is where you're wrong. I tried to explain
I know
this
common law.
night.
I know they only use common law whenever it benefits them.
I am not saying common law. That is the statutory provision trying to mirror what God set up. Okay? Did Isaac, when he married Rebekah, did he ever have a ceremony and a marriage license? No. It said the moment he saw her, he loved her from afar. And the moment he took her in the tent and consummated the relationship, according to the testimony in the Bible, that was his wife. You never once brought scripture into this to show that your wife was in dishonor according to her first contract, which was the marriage according to scripture. Trey Ben, you can't get in touch with her. I don't know what happened to her. But she did this for a guy in New Hampshire. His wife came after him. And guess what? When she argued from the scriptural contracts, she lost the case. Because that's what she used to show the wife was in dishonor. Because the state will never trespass on what is God's. The marriage license is the state's. The contract of matrimony is private.
Whenever I filed my response to their final orders, I did use scripture. I think I did as well in some initial documents as well. But the final one, whenever I voided all the contracts, whether it works or not, I did bring up the initial misjoinder of parties, because I have every right to self-determination, and I am not a person. And I've got probably 50 verses from the Bible that says that I have the freedom of religion. My religion tells me not to be the person, not to have respect for the person. So and I've contended that issue from the conception of this all. But,
okay, well, I have a question. Jeff. When you were going through all this, were you the executor over this state? or were you just going there and representing yourself and your what you think is your interest in and said in regards to the offspring?
Whenever I try to turn over the certificates, I do believe I stated that I was the beneficiary, and not sure if I said executor or not. I did plan to challenge his presumed position as executor decent tort, and because there is I do have a Texas code of conduct or rules of court that says that administrator is not allowed to act as executor.
I would love to see a certified true copy of your court case, because I would be almost willing to bet everything you've told us you've done, you're throwing out right terms a lot of times. And I mean no offense. And I hope to God I'm wrong on what I'm getting ready to say. I have a hard time believing that you have done everything you said you've done in the 6 months of studying. If you have mixed so many jurisdictions, the judge probably goes home and laughs at you.
Well, I have a question, and I'm
maybe
trying
I'm
to get
not
down
ready.
to
I'll accept that fact if I'm not. I mean,
Jeff. Okay, so is this a custody battle, a divorce? Like what is this proceeding over?
yeah, it's
I
a
didn't hear
custody
that.
battle. It's just one of the battles that I'm going through.
Okay,
But
so it's a custody battle, right? So at birth, did you go down and claim the minor estate as property, or did you leave the property abandoned?
I was still a blind sheep back then.
Okay, so you did. So you went in there, and you were never the executor over the state. You didn't have priority lien over the security instruments, which would be your children's birth certificates being authenticated. You haven't had their name changed. You haven't really done any of the things that are required to substantiate your claim of what you're trying to say when you go up there. So even if every word that was coming out of your mouth was exactly correct, if it's not, the record is not reflecting that, it's not going to matter. You have to move into the executive position. You've got to be able to have the lien over the children's estate. You have to be able to have all these things in place. You can't just go in there and act like they're just going to give you something because you're going to say something. They don't even hear you. It's like what the judge told that one guy. I think JW was telling me that the judge said, it sounds like you are a baby that needs a bottle. You know what I'm saying? I mean, you got to know, you got to go in there under the right conditions, man. You can't just go in there and think that you have, especially after you've abandoned everything and you don't have any control over nothing.
We did have an argument in the hospital last year in November when our third was born about signing the documents for the birth certificate. But what was I going to say? God dang it. Oh, I mean, I get what everybody's saying and following the process, but in the fundamental sense of justice, how is this in any way justice when it's all based on fraud?
Well, that's because your definition of justice is wrong. Yes, it did. It's just then, right? There's two definitions of the word. There's what we would, think of the word as justice being, and then there's their definition of it. And you're going in their world, and their definitions and terms are not the same as yours.
It's just us compared to them. Yeah, it's just them.
The big club, and you're not in it.
But how is this? I mean, just moral or just like fair.
It's not.
I mean, it's just business.
Yeah, you keep calling it fraud. It's not fraud. They publish everything to tell you how this system works. Look, I've been screaming it from the rooftops. Jesse, JW, Beth,
Not wash it
Bradley,
out.
Floyd, all these people have been hearing me for weeks talk about you are operating as the registered agent for the trust. And people have questioned my sanity over this, right? And what did I post today? I showed the registered agent. I only showed one thing, a screenshot, because there's 21 documents. I could go download them. Not a problem. Did I need to do the download? No. The point is, they publish everything. Once you know who you are as a player in this game, it changes how you operate. All your arguments that you are making in this court case, I made in my court case and fell on my face. I was pissed
not.
like you. But was it fraud? I said it was fraud the whole time. Now I look back and say, it's actually not. It's business. The 14th Amendment says you can't argue the public debt. They are bankrupt. They need you to play a part so they can create currency. You are fighting them on the creation of the currency instead of learning how to settle the debt privately so they go away.
That's what I am trying to do, trying to learn, because I know everything is commercial, even crimes, even kidnapping, even murder, according to 72 CFR, 27 CFR 7211.
Well, murder is not exactly listed, but yeah, I get what you're saying. But they'll never admit to 72.11 because I've looked it up on Westlaw. They'll never admit that. In the court cases I've looked up, people that have brought it up, they will not admit it. So that's what I've learned. Even though I know it to be a fact, don't bring up what you know they won't admit. Because why? You're in a public forum. They're not going to say certain things in the public. Public and private do not mix.
And so you asked for like producement in private chambers, right?
I've never done that. I've never once, in the 4 cases, 3 of my own, one where I actually assisted a truck driver in a careless and reckless, and I can call him today, and he will tell you, if it wasn't for me, he'd have probably went to jail. I went and stood toe-to-toe with the district attorney in that case. And in 4 cases, I have never once looked at a judge and said, can we go to private chambers? No. I went and said it things the right way to where I didn't, one, expose the system to where the judge knew what I was doing, to where the judge honored things. And this last case I had was a traffic ticket, never filed a stitch of paper in the court case, never went to court. I had a conversation with the clerk about what they were doing, and they sealed the record. Why? Because the state owns the name, and my job was to file the taxes.
Form 211 or what's that other one? 88 or 8821?
No, I didn't bring up any form numbers. I just said, hey, I need to verify your EIN, so because I'm in possession of a debt instrument, and I need to report it to the IRS. And why I'm a little bothered about going through the whole process with you is you are too gung-ho about throwing things at the wall to see if it sticks before you understand the process, that if I go through everything in that 8-minute phone call that I did with that clerk to make that traffic ticket go away, you will probably try it and you will be unsuccessful. Because, see, you were in a different court case. That court case, The controversy was between you and her. She's the problem, not the state. You were throwing things at the state, treating them like they're the problem, trying to make it go away. Now, if it had been, say, for example, that your wife wasn't the controversy and it was CPS instead, it would be a different story.
Right. That makes sense. Because he's doing it, taking the controversy to the wrong person.
Yes.
I knocked her up within 3 months of knowing her, and she's a Mexican national. She's a Mexican citizen and a Catholic, and yeah,
That's irrelevant.
Maybe we weren't meant for it. I just regret giving them a mother like her, I guess. I wish I would have known her true character a lot sooner.
Hey, do you believe that children are a gift from God?
I do, and that's why I'm trying
Okay,
to protect them
then
from her
why do
incompetence.
you regret creating something that God says is a gift?
Because she's going to get them hurt.
Does God control? Yes, God does. Then God knew what he was doing, and you're sitting here out of your own mouth saying, you know what, I regret doing this. I thought God, so you can't say God knew what he was doing.
I'm not trying to, I just, I don't know.
I know, and I'm not trying to be an ass.
I don't think I have the patience to put up with this. I don't think I have it.
You may not. That's between you and God.
I'm going to butt in real quick, and I'm going to say that if you don't have patience, if you hold on, I'm going to mute real quick. My son needs to ask me a question. I'll be right back.
And don't ask God to help you have patience. He'll give you trouble.
Okay, so
maybe she's right. Maybe I'm not worthy.
well, I don't think that's what's in question here. I think what's in question is, and what I hear, because I pay attention in a different way than what other people pay attention to. I can hear the anger that you have, and rightfully so. My daughters were taken from me when I was 19 by my own family. My own aunt and uncle took my daughters from me because they said I was too young to be a mother, and that they didn't like the gentleman that I was dating. And because my daughters were living with me in a trailer park and not in a home, and I wasn't married, I was unfit. When I went to court, the judge looked at me and said, you know what? King Solomon settled his. She was spitting Bible verses at me. Me being young, naive, and stupid, I was ganged up on every male person in my family, and it crushed me. I was angry, really angry. I mean, I can't even describe to you, and I hear that anger in your voice, but I'm going to tell you, if you don't have patience, if you do not have the ability to breathe, calm down, and actually figure out this process to help your children, because this isn't about you. This has nothing to do with you. And if you don't get off that high horse and learn that this is about your children, only your children, then I'm sorry, and I hate to be like this and say it this way, you're not going to accomplish what you're looking out to accomplish. You're going to end up in jail, and I don't want to see that happen to you. So I just wanted to butt in and just say, man, listen, take it from somebody who's been there, done that, lived in my car for 3 years, became a drug addict, almost tried to kill myself. I mean, I have been there. It's not worth the anger that you carry. You have to let that yoke go that is strangling you, and you have to understand that you're here in this group for a reason with all these amazing people that is going to help you, but you have to let them help you. So I'm not saying not to, voice out what it is that you're feeling, but
Mhm.
you gotta let them help you. Let them help you through the process. And is it going to take maybe a month or two? It might. But is it worth it in the end? Hell, yeah, it's worth it in the end. That is the goal. The end is the goal. And the journey you take to get there will be something you could tell your kids for the rest of your days, man.
You know, let me add to what you're saying, Beth. You know, the Bible talks about the law is a schoolmaster. And what is the schoolmaster's job? To expose your sin. Okay? We get angry at government. Government was created by God to punish the wicked. Okay? We see ourselves as holier than thou. We sit here and say, I'm not the wicked one. It's my neighbor that just got harassed by the government. So we sit by quietly and let it happen. I had someone ask me one time about a situation, the court case was going on, and they said, why are we going through this? I said, you know why? I said, ultimately it goes to this. We sit by quietly and watched other people's rights get violated. And the system built their traps along the way through case law, through the creation of codes and statutes. And guess what happened?
In
While we remained
acquiescence.
silent, it was just a matter of time before it was our turn. And now we're complaining. And now we're trying to undo all of it. So the study of law is a spiritual journey. If you don't realize that, you're never going to be successful at this. It will expose everything in you when you are searching it out the right way. And it will make you come face to face with what you did wrong. That's why I told you yesterday, what did we care about? I'm a man. You are a man. And from a man's perspective, what did I care about when I got out of school? I cared about chasing pussy. I didn't care about what my rights were. And when the government violated those rights, I got mad at government. When I'm the one that sat down and allowed it to happen because I didn't care enough to figure out what they were.
Are you talking about natural law? Or are you talking about like law that is man-made? Like I've
Man-made
been here
follows natural law.
because I've been hearing other teachers talk about how the courts are fictional, right? Courts are fiction.
Now,
So like
Susan,
how?
can you
Yes.
hold that thought? Because I was actually going to switch to you.
Okay.
I'm going to stop this recording